Thank you for joining us for this Charities Bite-Size webinar today. We're going to be looking at leasehold enfranchisement and the current reforms and looking to the future to see what's coming along down the line. We're not going to be focusing on tenants today, so this is largely around landlords. And there's a few housekeeping points that I need to cover off before we begin the actual talk. So we're going to send a recording of this webinar to you within a few days of the webinar concluding. If you have any questions, then please do put them in the question and answer box, which is at the top of your screens. If there's time at the end of the webinar, then we will take a few of those questions and come back to you on them. If not, then we will follow up after the webinar and contact you by email with an answer to the question that you've raised. Now, some of you will know Louisa Saunders. She was due to be on the webinar with us today, but unfortunately she's unable to join us. So I'm Nicola Lebish. I'm the co-head of Enfranchisement. I work on the transactional side of leasehold enfranchisement, and I have done so for approximately 20 years. I'm joined by Charlotte Wormstone, and together we're going to have a conversation about the current state of play with the leasehold enfranchisement and common hold. And we're going to be having a look at the areas which are shown on the slide here.
Good morning, everybody. Good afternoon, even. It feels like morning. I'm Charlotte Wormstone. As Nicola said, I am the co-head, along with Nicola, of the leasehold enfranchisement team here at Birketts. I am a property litigator, so traditionally I handle the contentious side of enfranchisement and have been practicing that for around about 15 years. So between us, we have a lot of experience in this area. So really, I think it's probably best that we start at the beginning. Nicola, do you want to take us through what enfranchisement actually is?
Yes, actually, that's a really good point, Charlotte, because I know some of you on the webinar will have conducted leasehold enfranchisement matters, and some of you may not have done. So right back to basics, leasehold enfranchisement describes a body of legislation which applies to leasehold residential dwellings. And it essentially allows tenants to enhance their position either by extending their lease or claiming the freehold of their house or a block of flats.
That's right. And until very recently, there have been two main pieces of legislation that have governed enfranchisement, those being the Leasehold Reform Act 1967 and the Leasehold Reform Housing and Urban Development Act 1993. So those two pieces of legislation have largely provided a framework for lease extensions, freehold and collective enfranchisement for a period of almost 60 years. However, last year, 2024, we were presented with an update to that body of legislation in the form of the Leasehold and Freehold Reform Act.
Important to note, some of you may be aware of legislation which relates to the disposal of a block of flats by a landlord, which may necessitate first offering that block to the tenants within that block. It's known as the right of first refusal, and it arises under the Landlord and Tenant Act 1987. Now, so far as we're aware, there are no existing or proposed reforms in relation to that act. So despite it being in dire need of update, unfortunately, we haven't got that clarity from the government, and our talk will not look at that today.
Important to say as well that some of you will be aware of the Renters Reform Bill that's coming over the hill this year. We're not going to touch on that either today because it deals with short lease matters and we're dealing with exclusively long lease matters today. However, we do have resources that talk clearly about the legislative changes and experts within our teams that know an awful lot about it. So if that was something of interest, then please do let us know and we can pass on your details to those people. So having mentioned briefly the 2024 Act, which is the in full title is Leasehold and Freehold Reform Act 2024, which we lovingly refer to as LUFRA. Nicola, can you run down for us, please, what the changes are intended under that piece of legislation?
Of course. So the Act essentially seeks to make it easier and cheaper for leaseholders to extend their leases or acquire the freehold of their block of flats or their house. And it does this in several ways. So at the moment, the 1993 Act allows for a lease extension of 90 years. What LUFRA does is extend that lease extension period to 990 years. It also reduces or actually eliminates the qualifying period that a tenant must attain before they can claim an extended lease or their freehold. Previously, it was 2 years. Under LUFRA, it's nil. It changes the position on where costs lay in relation to a claim. So under the 93 Act, tenants are largely responsible for the landlord's costs, both their legal fees and valuation costs, within the parameters of the Act. And we usually see landlords recovering between 70 to 80% of their costs. Under LUFRA, the provision is that each party bears their own costs, except in a very limited number of circumstances, and that is largely tied to the level of premium that's being paid. So if the premium is very low, then it may be the landlord will be able to recover some of their costs from a tenant on a statutory claim. And for tenants who wish to acquire the freehold of their block of flats, which is mixed use, currently under the 93 Act, if 25% or more of the floor area is commercial, then the tenants do not have a right to acquire that freehold. That's changing under LUFRA, and the percentage will go to 50%, which will bring a lot of mixed-use buildings within the ambit of the Act that weren't there previously. The Act also largely bans the creation of new leasehold houses, so much mooted in the news and discussed about. The government does not like this, and for developers that's absolutely fine. Arguably, they should be passing on the freehold rather than a long lease. But there are situations for charitable housing trusts and housing associations where it's essential to be able to grant a lease of a house under a shared ownership lease, and the position on that is not set to change. There are also protections for homeowners being introduced where there are freehold estates and there are managed areas. The person responsible for managing those areas can ask the freeholders for a contribution towards the costs, and that is currently unregulated. That's been brought into something akin to service charge and the regulatory provisions around that. And in relation to service charges, service charge demands are set to be issued in a standard form, so a landlord wouldn't be free to adopt whichever form they wished to. LUFRA also includes a ban on commission from from buildings insurance, and litigation costs will no longer be recoverable from tenants. There's also the Act also allows for regulation of managing agents, which is probably long overdue. And it also removes marriage value. But not everything is actually in force under the Act, is it, Charlotte?
No, that's right. In fact, out of that very long list that Nicola has just read out, there are at present surprisingly few of those that have actually come into force. So in January, the 2-year ownership rule was abolished, meaning that those that purchase flats should not then have to wait 2 years in order to extend their lease. So prior to this, we've used a process of assignment of a benefit of a Section 42 claim notice and of the benefit of the subsequent claim. And that meant we had a process whereby we could circumvent the 2-year ownership rule where flats were changing hands. But the process was not and is not without risk to the incoming owner as to the validity of the assignment or indeed the claim itself. So whilst this enactment might appear to reduce or mitigate that risk and smooth the process over, unfortunately, the ever-increasing delays at HM Land Registry means that it can take almost the 2-year ownership period, as was, for the registration of the legal interest to come onto the register, meaning that the incoming tenant is still a little hamstrung in what it's able to do in terms of dealing with the leasehold interest, and that would include extending the lease. There are processes by which you can make an application to expedite at Land Registry, but that doesn't always speed it up very much and isn't always available. So we really do have to see how much this particular provision improves the situation. As you can see, legislation and the bodies that deal with registration are somewhat separate in this, so it remains to be seen. The second provision to be enacted was in March, and that came into force being the change to the percentage floor area in mixed-use buildings. And that would dictate whether or not the building was eligible for the right to manage. So the right to manage is the process by which the collective body of tenants take over the management of a building. It's a step away from effectively from freehold enfranchisement, where they take on the legal interest in the freehold. Previous legislation, the right to manage could only be exercised in a building where the non-residential parts made up no more than 25% of the floor area of the building. Under LAFRA, this threshold is raised to 50%, and that should allow for more mixed-use buildings to fall within the right to manage regime and allow tenants to take more control. However, from personal experience, we've not seen an immediate uptick in the applications as a direct result of this increased threshold. It does remain to be seen, though, whether this allows more tenants to take the controlling interest in running such buildings, whether they're interested in doing so. It might be, though, that these same tenants that are looking for more control might be, if they've taken some legal advice on this, they might be looking to see whether the more impactful provisions under the Act are going to be brought into force, and considering such options as collective enfranchisement as a preferable alternative. But that really remains to be seen.
Even though the majority of the provisions are not yet in place, we're starting to see challenges to that piece of legislation. And there's an interesting challenge regarding the removal of marriage value, which does involve several charities.
Yes, that's right. It's probably known in the press as the John Lyons Challenge, because the John Lyons charity is the one that is at the forefront. So John Lyons Charity has, alongside 6 other applicants, launched a legal challenge against LAFRA. The charity is arguing that the reforms will significantly reduce the income from their freehold interests, the funds from which fund various community projects across what I'm told is 9 London boroughs, so quite significant. And the main contention, the main contention is the exclusion of marriage value. Now, marriage value is the increase in premium which is paid by a leasehold owner when extending a lease, where that lease term has fallen below 70 years. And these reforms will lead to a substantial wealth transfer in the charity's argument from freeholders to leaseholders. They're calling it an expropriation of the value of their property without adequate consideration. And between the 7 applicants, they're estimating their losses to be around £3.6 billion over a period of 10 years. So by no means insubstantial. John Lyons itself has estimated that the annual loss for them would be 1.4 million, which obviously would severely impact their ability to fund things like youth clubs, holiday activities, and other community services that it currently provides financial support to within the communities that it operates within. And the charity is leading on a High Court declaration that LAFRA is incompatible with the right to property under the Human Rights Act 1998, arguing that the reforms basically unfairly benefit wealthy property owners, including non-doms and tax exiles, at the expense of charitable organisations, leaving them unable to deal with their freehold property as they see fit to do so in order to bring those funds into the charitable arena. So this legal challenge really highlights the broader implications of LAFRA on charities that rely on their property income to support philanthropic activities. Interestingly, though, as Nicola has said, this provision is not actually in force yet. However, the courts have seen fit to allow this challenge to proceed on the basis that it is already having an impact, notwithstanding that it's not been enacted. So that's really showing how seriously this is being considered. However, LAFRA is not the only legislative change on the horizon. You've no doubt heard talk in the press about Commonhold. And this is a proposal an outright ban on new leasehold developments, replacing our centuries-old structure of leasehold and freehold with a new one that seeks essentially to put those who reside in flats in more control of the environment in which they live, and to provide an appreciating rather than a depreciating asset. Nicola, perhaps you can take us through some of the proposals and the differences between the new and the existing regimes.
So Commonhold, it's a form of land ownership which is adopted in other countries, albeit by a different title. And it essentially means that a person acquires a unit in a building and becomes a member of a company which holds the building in common areas called a Commonhold association. Rather than there being a lease which governs the relationship between the company and the unit holder, there is a common hold community statement which regularizes the position between the unit holders and how the common areas are managed. Now, there are some significant differences here compared to leasehold ownership of property. So there's no contractual relationship between a discernible landlord and tenant. Instead, there's a common hold community statement which sets out the rights and responsibilities of the parties. And it means there's complete unity across all of the unit holders, which makes it easier to vary the terms by which the unit holders are governed, since the community statement can be amended itself rather than varying swathes of leases to bring about a change. It also means that you're not caught by a provision in a lease which may say that all leases have to be in the same form. Here, it literally is one statement that can be amended by resolution of the company. Now, there's no landlord, though, to provide financial stability or enforce the provisions of a lease. And this means that the unit holders must ensure that the company remains solvent. If the company isn't solvent, then there's the possibility of the building and the land reverting to the Crown, which would not be a very happy situation for any of the parties involved. Now, there is greater control for unit holders, but managing a building is complex, and in common hold, that falls to the unit holders. Whereas in a landlord and tenant relationship, the landlord is often a company or professional body which can manage those complexities. As Charlotte has said, common hold creates permanent ownership rather than a lease, which has a diminishing term. So it's very attractive to unit holders from that perspective. One of the major differences is that there's no sort of concept of forfeiture in a common hold arrangement. Obviously, where you have a leasehold property and the tenant defaults sufficiently that a court will allow possession of the flat in question, that then reverts to the landlord. The landlord can reissue a lease, grant a lease for a premium and keep the premium. In common hold, whilst the unit holder can be expelled from the common hold community, they are still entitled to the proceeds of that asset. So that would then be sold to somebody else and they would receive the net proceeds of sale from that.
So where are we with common hold? Well, the white paper I'm sure you've heard talk of was issued in March this year, and that has provided a framework for how the government intends to reinvigorate common hold and make it more attractive. It having sat very much in the shadows for the last 2 decades since it was brought into law in 2002 in actual fact. And the white paper is a precursor for the bill that is expected later this year, with the intention that the government will make common hold the standard tenure for newly built flats by the end of the current parliament. So predictions are 2029. There's been very significant discussion now about how common hold will work in practice. Will it result in a tenure that is more beneficial to tenants than leasehold, or will it result in something remarkably similar in actual fact, just under different legislation? How will unit holders work together as common hold associations to run the building? As Nicola says, there are many complexities, and we see it with right to manage, where tenants believe they can do a better job than the landlord, and so step in and try and run it themselves and manage managing agents, and actually find that it's very complex. The right to manage company goes under and we're all back to where we started, and in fact then they start a collective enfranchisement process. There are also issues about, will there be buy-in from day one, a day-to-day basis, or will people lose interest, as we often see, as I say, in right to manage? On the other side, common hold does provide, as we've said, unit owners with more autonomy regarding the building and their own unit. So consent for works should be easier to obtain. Changes to the way that service charges are run, collected, managed should be, again, more smooth, as this can be done by resolution of the company rather than by deeds of variation or even an application to the tribunal. Of course, there are arguments, as always, both ways, and we will probably not know really for sure which way it will go until we see it in practice and on a much larger scale than now. Having been in force for over 20 years, we have only got somewhere between 15 and 25 common hold associations registered at Companies House, and whether those have been done properly and whether they're being run in effect as common holds is anyone's guess. The other issue to consider in this will be the lending community and the certainty that will be needed to be presented to lenders when lending against common hold. At present, it seems that there are very few lenders in the market that will entertain a common hold. So there's a very long way to go with those stakeholders. And beyond that, there is a whole-scale re-education as to how flats are owned and some very considerable thought to be put into how present leasehold structures might be converted into common hold in the future, and what kind of compensation will be paid to freeholders when that happens for the loss of that asset. It might be that we look at something along the lines of the collective enfranchisement process that we have at present, which brings me back to saying, as I said at the beginning of this section, how different will common hold actually be to the present situation? So given these significant shifts that we've been talking about, Nicola, what kind of preparations or mitigations do you think that our clients should be considering? What do you see coming on the horizon?
So I think, firstly, resist the urge to divest yourself of your residential property portfolios, yes, although that might be quite strong. And it's important to say that decisions obviously can't be taken in isolation, and speaking to all of your advisors is important. But from what I'm seeing is landlords seeking to offer long leases now, so to essentially take advantage of the fact that LUFRA is not in full force, and marriage value does still exist, but seeking to offer voluntary lease extensions to their leaseholders to seek that return on investment now and avoid the problem later when I suspect marriage value will actually be removed. And some of that uncertainty is we just don't know what will replace it. So what we do know is what's under the 1993 Act, and what our enfranchisement valuers know is how to value that. So it's important to see if that is an option for you for return on investment before LUFRA comes into effect. And certainly a few of my clients have gone through the exercise of offering long leases. Unfortunately, some tenants don't understand that LUFRA isn't in effect. So if you are going to go through this exercise, my advice is to make that very clear to them, be upfront with them about what their current rights are, or to take an even longer term view and agree to grant a lease on the basis of LUFRA, but making sure that if leases are below 80 years, you do still get the marriage value. And there are some opportunities to maximise on development value where, if I take an example of a sort of masonette building, you have maybe the garden demised with a flat downstairs, upstairs you have a flat, but you've kept hold of the loft space. And we often find that tenants want to develop into the garden or develop up into the loft space, and there is an opportunity there to charge a premium for those two areas, to change their use and to bring them within the ambit of the tenant's flat itself. I'm sure there are things that you're seeing from your perspective as well, Charlotte.
Yes, I'm just thinking about sort of more development clients, and I have definitely seen some rooftop developments. So clients with large portfolios that are looking at the availability of space on roofs. So buildings with flat roofs, obviously, whether they can support, quite literally, rooftop development. Obviously, building out additional leasehold units on a roof will bring about an immediate injection of cash from the large market value premium to be paid for a long leasehold interest. Obviously, that's quite a specific issue, and there are many considerations to be put into place, not least of all 87 Act matters around granting development leases of roof space and airspace in order to have those units built out. However, we are specialists in this, and we are definitely making way for structures that allow this to happen. As I say, it's a very specific issue, but we are seeing it in the market, definitely.
Thank you. And I think that's the things that we wanted to talk to you today about, to sort of raise awareness of these issues, to give you some sort of food for thought on what you might wish to do in the future. And we do have time for a few questions. So I can see one question at the moment, which is, what happens if unit holders cannot agree, for example, amendments? How is this then dealt with? And that really is, I think, one of the major problems of Commonhold. One of the biggest things I think that people will find it difficult to deal with is this sense of community, that you're all actually pulling together for the greater good of each other. And I think in England we are, very aware, this is my little slice of land, this belongs to me. And changing that concept and that view to we are a community, we need to try and act together. I think it would take quite a lot of diplomacy to either be able to bring about a change, which most people don't want, or to accept that a change won't happen. But I believe it's a resolution of 50% of the company. Is that right, Charlotte?
That's correct, yes. Effectively, it's a limited company and it's run as such, and therefore decisions are made based on effectively the articles of the company. Of course, that's going to leave some people as the minority voters and leave other people disgruntled, but that is the way that it's intended to be run. But Nicola's quite right. It's about community living, and if there are issues with blocks of flats at the moment, it's to do with people not understanding that living in a block of flats is community living. So I'm not entirely certain that Commonhold will get rid of any of that. But in direct answer to your question, yes, it's run as a company and those decisions are based on voting rights.
So I suppose for tenants, the question is, have they got enough people to support a change before they put it before everybody to vote? So all those sort of tactical things about running a company and making sure that you've got people to vote with you are going to come into play. And that's just not something that everyday people are used to. So it's going to be interesting to see how all of that can be ironed out.
Yeah.
So we've got a few more minutes if anybody else has any questions they would like to raise. Alternatively, if you have any questions which you think of after this webinar, then we'll be very happy to take them by email and we can respond to you.
Otherwise, thank you very much for your time, and it's been lovely to speak to you today. Thank you.
Thank you all.